The Democrat sponsors of this bill are acting just like King George III. In the Declaration of Independence, the Americans declared that King George was unfit to rule because he was forcing them to be tried overseas by his tame courts for made-up crimes. The Democrats today are doing the very same thing. They pass unconstitutional laws to make law-abiding citizens criminals, and then they make those same citizens travel hundreds of miles to a kangaroo court that they control.
That was State Representative Dan Calkins when they debated a measure that Governor J.B. Pritzker signed yesterday with little fanfare to limit Illinois citizens' ability to file lawsuits challenging the constitutionality of state laws or executive orders in state courts. Welcome in Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Springfield's News and Talk, and the governor, his office releasing this statement just briefly, not even a statement, really. It's just an announcement that the governor took action on House Bill 3062, which sets a venue for actions asserting constitutional claims against the state. Illinois has 102 counties, but this measure that Democrats passed in a partisan manner would only allow for citizens to sue in state courts in Sangamon or Cook County, not any of the other 100 counties that there are across the state of Illinois. So we've talked about this in the past, but now it's law. It's effective immediately. And we'll hear the debate from the Senate and the House and how contentious it was. Various voices in on this. And you've got State Senator Don Harmon. You've got State Senator Terry Bryant, State Senator Jason Plummer, all sounding off on this. And here is how it sounded when it passed the Senate before the legislature adjourned this spring session just a handful of weeks ago.
They can bring a great variety of causes of action, including those relating to the Constitution in any county. This is a very limited case. It's where the cause of action is against the state itself or one of our officers, seeking declaratory or injunctive relief against a state statute on the basis that it's in violation of the Constitution.
This is a terrible bill. We have circuit courts in this state for a specific reason, and that is so that people are able to go to their courts and have their grievances heard, not so that we can make it more convenient for the person that was mentioned previously, which is the Attorney General. This is a very bad bill. And every single one of you should be paying attention to this because you have a responsibility. I have a responsibility. The sponsor has a responsibility. Even the Attorney General has an office in Carbondale. Why? Because he wants to be close to the people that he's serving. This is a terrible bill. Vote no.
This is a small subset of cases typically brought. It is not the routine cases and controversies most people would bring. It is a relatively extraordinary action. They all eventually end up in the Supreme Court, which, by the way, sits in Sangamon County and Cook County. So it makes sense. And again, it is not new. There are a variety of statutes today that say venue is proper in Sangamon or in Cook.
People that can't afford fancy lawyers and expensive lawyers, people that might struggle to be able to pay filing fees, have to go to Sangamon County and Cook County to hear their concerns or have their concerns heard. This is offensive to the people of Illinois. And with all due respect to the president, I think some people in this body are starting to forget who works for who. The judiciary does not work for the legislature. The legislature does not work for the constitutional officers. And the judiciary and the legislature and the constitutional officers work for the people of Illinois. And it's time that you start showing some respect to the people of Illinois, quit limiting their rights, quit taking their rights away, and frankly, when we take their rights away, at least give them the decency and the respect to allow their concerns about their rights being taken away be heard in a local courthouse. This is an affront to democracy. I urge a no vote.
So again, that was some of the debate from the Senate floor when the measure passed, and that's House Bill 3062, passed along partisan lines. Governor J.B. Pritzker signing that yesterday, and a lot of opposition heard on the House floor as well when this measure passed. Again, along party lines, with Republicans opposing this and Democrats supporting it. And here we have the House debate where you'll hear from the House sponsor, State Representative Jay Hoffman from Swansea. Also, you'll hear State Representative Patrick Windhorst, a Republican from down south Illinois. You've got State Representative Dan Calkins, who's one of those state representatives who filed a lawsuit against the state over the gun and magazine ban. He says that this is tyrannical, very similar to King George III, but also Dan Ugasti, another Republican opposing this measure for a variety of reasons. Here's how it sounded on the House floor when they brought this measure up and passed it along party lines before they adjourned spring session.
Initiative of the Attorney General of the state of Illinois, and would indicate that Sangamon and Cook counties are the only venues proper for Illinois constitutional claims. Over the past 3 years, the Attorney General's office has been forced to respond to, I would call them in many cases, frivolous lawsuits that have strained the office's limited resources.
This is the same Attorney General's office that has requested from this body additional authority to investigate and bring actions against crisis pregnancy centers this session, to bring actions against and investigate gun manufacturers this session. It doesn't seem that the Attorney General's office is lacking in resources when they're constantly coming to this body requesting more authority to do things. So I think that argument strains credulity.
What was that word?
I'm not sure.
Credulity? What did you say? Okay. Interesting.
I'm trying to test the typist upstairs.
Yes.
We have seen many counties throughout our state pass resolutions saying, we don't feel a part of the state of Illinois. We don't want to be a part of the state of Illinois because they're passing these resolutions because they don't feel the respect from certain parts of the state of Illinois. And what this bill does is it basically says, you're right. You can't go to court in your local jurisdiction. You can't get justice in your local jurisdiction. You've got to come to Springfield or Chicago to get justice. And that is fundamentally wrong.
The Democrat sponsors of this bill are acting just like King George III. In the Declaration of Independence, the Americans declared that King George was unfit to rule because he was forcing them to be tried overseas by his tame courts for made-up crimes. The Democrats today are doing the very same thing. They pass unconstitutional laws to make law-abiding citizens criminals, and then they make those same citizens travel hundreds of miles to a kangaroo court that they control.
We are now about to affect an individual's right in this state to challenge the constitutionality of laws and executive orders to solely 2 counties. We are denying access to courts. And as the sponsor already pointed out, if it's a problem for the Attorney General's office, there's a remedy that exists. The Supreme Court of Illinois will consolidate the cases. A petition can be filed, and the cases can be consolidated already in a venue of the Supreme Court's choosing.
There have been judicial shopping by filing TROs without early notice to the Attorney General's office, whether they were COVID-related restrictions, whether they're masks, whether they're vaccines, whether they're safety acts, whether they're assault weapons ban, and the list goes on, to the extent that one lawyer was charging people $200 just to have their name added as plaintiffs to the lawsuit. Now, where have these cases ended up? They've ended up in Sangamon County. They've ended up here.
So again, the governor signing this measure yesterday with no fanfare, just a statement from his office saying that the governor enacted this bill, House Bill 3062, and it's effective immediately, meaning that if you have a problem with Illinois state statute or executive orders from the governor, that means that if you live in Southern Illinois, you can't file in your local county court in Southern Illinois. No, you got to travel either to Springfield or all the way across the state, hundreds of miles, to Chicago to file a claim against the state. So obviously this is something that people have speculated is a bit of an indication of what they fear could happen with future laws or even executive orders. And you saw during COVID, all of the executive orders, everything from limiting people to go to church or limiting people's ability to gather with others, and regardless of the size, to closing businesses, to keeping kids from school, to requiring masks or requiring vaccines. All of those things were challenged in the courts, in various courts all across the state. And this measure now in effect, if there was another pandemic or another string of executive orders the governor wanted to implement, if you wanted to challenge those, you'd have to go either to a court here in Springfield or all the way up in Chicago. And people pushing back saying this is tantamount to tyranny. It's an affront to democracy. Those aren't my words. Those are words of the opponents of this bill. And after I just posted a screenshot and these videos of the debate, the reaction, at least on Twitter, has just been pouring in overnight, talking about how this is absolutely detrimental to democracy and the fundamental understanding of how our court system is supposed to work, and people expecting this to be challenged, not in state court, possibly in state court, but they could possibly even go to federal court to challenge this, which this does not impact which federal court you can go to challenge things. You can still challenge these things in federal court in the Southern, Central, or Northern District of Illinois at your choice. Those are the federal courts. This only impacts the state courts. Whether or not it will stand constitutional muster, we shall see. But obviously, a lot of reaction to this measure being signed with no fanfare yesterday. The governor announcing that he signed it, and that was pretty much it. It's effective immediately. So if you have a problem with a state law or an executive order and you want to challenge the constitutionality of it, you can't go to your local court unless you live in Sangamon County or in Cook County. If you live in Effingham County, you're going to have to travel to one of those two counties to file that constitutional claim. So just another day here in Illinois, and a lot of reaction to what people are seeing as and characterizing as tyranny in the land of Lincoln.